A staggering $15 billion lawsuit filed by a sitting president against one of the nation's most prominent newspapers, thrown out by a federal judge. The dismissal was not just a quiet procedural move. It came with a blistering critique, labeling the legal complaint a megaphone for public relations and a public forum for vituperation and invective. This wasn't merely about a legal dispute. It was a clash between the highest office in the land and the free press. But how did it come to this? And what does the judge's decision truly mean for the ongoing battle over information and accountability? To understand the full picture, we must dissect the complaint, the judge's ruling, and the fundamental legal principles that govern our democracy. The core of this conflict began when President Donald Trump filed an 85-page lawsuit against the New York Times, 4 of its reporters, and publisher Penguin Random House. The suit alleged a coordinated and malicious campaign to defame him, particularly in their coverage related to the 2024 presidential election and a book titled Lucky Loser. The president's legal team accused the newspaper of acting as a mouthpiece for his political rivals, aiming to destroy his reputation and prejudice legal proceedings. The sheer scale of the damages sought, $15 billion, signaled this was intended as a heavyweight legal fight, aiming to deliver a decisive blow against what the administration frequently labels as fake news.
However, the lawsuit was halted almost as soon as it began. U.S. District Court Judge Steven Merryday, an appointee of former President George H.W. Bush, dismissed the complaint on procedural grounds, calling it decidedly improper and impermissible. The judge's ruling was not on the merits of the defamation claim itself, but on the very structure and content of the filing. He criticized the lawsuit for its excessive length and its inclusion of what he termed superfluous allegations and lengthy praise for the president's own accomplishments. Judge Merryday was clear: a legal complaint is not a political rally or a press release. It is a formal document with specific rules. In his written order, Judge Merryday emphasized a foundational principle of the legal system. He stated, "As every lawyer knows, or is presumed to know, a complaint is not a public forum for vituperation and invective, not a protected platform to rage against an adversary." His words painted a picture of a legal filing that had strayed far from its intended purpose. The judge noted that the actual legal counts against the newspaper were buried in the final few pages, preceded by dozens of pages of political rhetoric. He compared the improper use of the court to London's famed Hyde Park Speakers Corner, a place for open-air public debate, not formal legal proceedings. Despite the lawsuit's dismissal, the door was not permanently closed. Judge Merryday granted President Trump's lawyers a 28-day window to file an amended, corrected lawsuit. However, he attached strict conditions. The new complaint must not exceed 40 pages, less than half the length of the original. The judge's instructions served as a firm warning. This action will continue, and will end in accord with the rules of procedure and in a professional and dignified manner. This essentially forces the president's legal team to strip away the political narrative and present a focused, legally compliant argument if they wish to proceed with the case in federal court. The reaction from the New York Times was swift and pointed. A spokesperson for the newspaper stated, "We welcome the judge's quick ruling, which recognized that the complaint was a political document rather than a serious legal filing." This sentiment echoed the judge's own critique, framing the lawsuit as a public relations stunt rather than a genuine legal grievance. From the newspaper's perspective, the dismissal affirmed their view that the lawsuit was an attempt to use the court system to attack and intimidate a news organization. The focus now shifts to whether the Trump team will refile a complaint that can withstand legal scrutiny, a challenge that requires moving from political rhetoric to precise legal argumentation.
In the face of this legal setback, President Trump projected confidence and defiance. When questioned by a reporter in the Oval Office about the judge tossing out his case, the president's response was simple and direct. Immediately after declaring victory, the president turned his criticism toward the journalist and his network, illustrating the administration's broader adversarial stance with the press. This exchange encapsulates the administration's strategy, portraying legal and political challenges not as setbacks, but as ongoing battles in a larger war against a biased media. A spokesperson for the president's legal team reinforced this message, stating their intention to refile the lawsuit and, quote, continue to hold the fake news accountable. This public posture suggests that for the administration, the political value of the lawsuit may be just as important as the legal outcome. It serves to rally supporters around the idea that the president is under constant attack from established institutions and is the only one willing to fight back against them.
So, what specific legal rule did the president's lawsuit violate? The issue lies with a core tenet of the Federal Rules of Civil Procedure. This rule mandates that a legal complaint must provide a short and plain statement of the allegations to show that the filer is entitled to legal relief. The purpose of this rule is to ensure clarity and efficiency in the judicial process. A defendant must be able to clearly understand the specific claims being made against them so they can formulate a proper defense. The judge concluded that the sprawling 85-page document from the Trump team failed this most basic test, describing it as a meandering complaint. As the judge noted, this is a standard that every lawyer practicing in federal court is presumed to know intimately. The failure to adhere to such a fundamental requirement raised questions about the legal strategy behind the filing. Was it a deliberate attempt to use the court filing as a political document, knowing it might be procedurally flawed? Legal analysts suggest the primary issue was the attempt to use the courts as a public forum to, in the judge's words, rage against an adversary. By failing to comply with the rules, the president's team opened the door for this swift dismissal, delaying any potential progress on the actual substance of the defamation claims.
This case also intersects with other administration actions regarding the press. On the same day the lawsuit was dismissed, the Pentagon announced new rules restricting reporter access and the flow of information about the military. Under these new guidelines, journalists are required to pledge not to gather or use any information that has not been formally authorized for release. Violating this rule could lead to reporters losing their credentials, effectively cutting off their ability to report from inside the Pentagon. This move, combined with a new rotation program that removed several major news outlets from their Pentagon office spaces, signals a broader, coordinated effort to control the narrative coming out of key government institutions. These parallel events, a lawsuit against a newspaper and new restrictions at the Pentagon, paint a picture of an administration actively working to manage and control its relationship with the press. While the lawsuit uses the courts to challenge media coverage directly, the Pentagon rules use administrative power to control access to information at the source. Both actions can be seen as part of a strategy to challenge the traditional role of an independent press as a government watchdog. Supporters of the administration might view these moves as necessary steps to combat biased reporting and ensure national security, while critics see them as a dangerous erosion of transparency and a threat to the public's right to know.
Beyond the procedural issues, if this case does move forward, President Trump faces an incredibly high legal hurdle. For a public figure to win a defamation lawsuit, they must prove more than just that a false statement was published. They must prove it was published with actual malice. This legal standard is a cornerstone of American free press protections. It means the plaintiff has to demonstrate that the defendant knew the statement was false when they published it, or that they acted with a reckless disregard for the truth. This isn't about negligence or a simple mistake. It requires proving a deliberate or highly reckless act of falsehood. The actual malice standard was established in the landmark 1964 Supreme Court case, New York Times v. Sullivan. The court's ruling was deeply rooted in the history of the First Amendment, which was designed to prevent the government from using libel laws to silence critics, a common practice under British rule. The Supreme Court recognized that the mere threat of expensive lawsuits could have a chilling effect on speech, discouraging journalists and citizens from reporting on and criticizing public officials. The high bar of actual malice was therefore created to give the press breathing space to do its job, ensuring robust and uninhibited public debate, even if it includes occasional errors. The logic behind this high standard is that public officials, like the president, have significantly more access to the media to counteract any false statements made about them. They can hold press conferences, issue statements, and use their powerful platforms to present their side of the story, an option not available to private citizens.
Therefore, the law places a greater burden of proof on them in a defamation case. Proving that a news organization acted with a deliberate intent to lie or with reckless disregard for the truth is an exceptionally difficult task. It requires getting inside the minds of the reporters and editors, which is why so few defamation lawsuits brought by public figures are successful. However, the legal landscape surrounding defamation and the First Amendment may be shifting. In recent years, there has been a growing movement to have the Supreme Court revisit and potentially overturn the New York Times versus Sullivan precedent. Several conservative justices on the current Supreme Court have indicated they are receptive to reevaluating the actual malice standard. They argue that the standard provides too much protection for a media landscape that has changed dramatically since 1964, allowing for the rapid spread of misinformation with little accountability. A successful challenge to this precedent would fundamentally alter the balance between protecting reputations and protecting free speech.
A change to this 60-year-old precedent would represent one of the most significant shifts in First Amendment law in modern history. If the actual malice standard were to be weakened or eliminated for public figures, it would become much easier for politicians and other officials to sue news organizations for critical coverage. Media outlets, fearing costly litigation, might become more cautious in their reporting on powerful people, potentially leading to less investigative journalism and government oversight. This is the chilling effect the Supreme Court sought to avoid in 1964. Therefore, President Trump's lawsuit, while currently stalled, is part of a much larger national conversation about the future of press freedom in America. So, what comes next in this immediate legal battle? The ball is now in the court of the president's legal team. They have been given an opportunity to fix the procedural errors in their original complaint. As their spokesperson has already indicated they intend to do, they will need to draft a new lawsuit that is concise, focused, and free of the political rhetoric that the judge admonished. This new document must clearly and plainly state the specific defamatory claims and the evidence supporting them, all within the strict 40-page limit set by the court. Only then can the case proceed to the next phase of litigation.
Assuming a new, compliant lawsuit is filed, the legal fight will truly begin. The New York Times' legal team would then respond, likely with a motion to dismiss the case on its merits, arguing that the president cannot meet the high actual malice standard. This will be, as legal experts have noted, an uphill battle for President Trump. He would have to prove not just that the reporting was biased or unfair, but that the journalists knowingly published lies. It's a significant challenge, but one the president seems determined to pursue as he continues to wage his broader campaign against media organizations he deems hostile to his administration. This case remains a critical one to watch.